Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have an update to the docket in the Blake Lively versus Justin Baldoni legal case. Yesterday, Justin Baldoni's lawyers doubled down, writing to the judge to request that the frankly obscene, as they put it, subpoenas be quashed. Dear Judge, as counsel for Wayfarer Studios, Justin Baldoni, Jamie Heath, Steve Sarowitz, etc., we write in response to the letter dated February 15 from counsel for Blake Lively and Ryan Reynolds concerning their subpoenas to cellular providers AT&T, Verizon, and T-Mobile. In their letter, the Lively parties misrepresent the scope of the subpoenas, contending that they seek only non content records such as call, text, and data logs, and not the content of any communication. That is flatly false. The subpoenas demand all documents concerning ingoing and ongoing calls or text messages related to phone number redacted, belonging to each of the individual Wayfarer parties, some of their employees, and various non party individuals, including but not limited to call logs, text logs, data logs, and cell site location information. As defined in the subpoenas, documents is synonymous in meaning and equal in scope to the usage of the term documents or electronically stored information. In turn, Federal Rule 34 states that documents or electronically stored information includes writings, drawings, graphs, charts, photographs, sound recordings, images, and other data or data compilations. Well, that'd be like a mountain of shit to go through. If the Lively parties were seeking only call, text, and data logs, their subpoenas would have asked for all call, text, and data logs for phone number redacted. But that is not what they actually ask for. Instead, the subpoenas seek all documents relating to the various phone numbers, which is a request of the broadest possible scope and clearly encompasses content as explicitly requested, location information. To the extent the Lively parties are, in fact, merely seeking logs, then their subpoenas should so state. As drafted, however, the subpoenas seek precisely what we asserted in our February 14th letter to the court, namely all documents relating to the listed phone numbers in the possession, custody, or control of the cellular providers. Whether the providers actually have content, browsing history, location data, and the like is an open question, but it is not one we are prepared to see answered only at the time of production. In sum, the subpoenas are overbroad on their face. The Lively parties cited two cases for the proposition that the scope of the subpoenas is permissible. Both are inapposite. The Smith v. Maryland case is a criminal case, and case law concerning the permissible scope of Fourth Amendment searches and seizures has no bearing whatsoever on the scope of permissible discovery in civil litigation. The case of Ugorgi versus Department of the Environmental Protections of the State of New Jersey, while not controlling in this district, is similarly distinguishable. Unlike here, the facts at issue in the case gave rise to an arguably justifiable basis for the sweeping nature of the subject request. In Ugorgi, an employer sought to prove that an employee was engaged in inappropriate, non work related activities during business hours, and the employee's cell phone records were, as alleged, relevant to that allegation. Nothing in this case supports such broad disclosure, and the Lively Party subpoenas lack even a modicum of tailoring, as required by Rule 26B of the Federal Rules of Civil Procedure. The Lively Party's preposterous assertion that their plainly overbroad subpoenas should be waved through due to insufficient meeting and conferring must be rejected out of hand. The parties held a meet and confer conference on February 14th. It's nice that they spent Valentine's Day together. During which the Wayfarer parties explained that the breadth of information sought by the subpoenas is, frankly, obscene, and that the plain language of the document request does not support the limited scope suggested by the Lively parties. Moreover, a certain of the providers have already contacted our clients, indicating they intend to comply. Given the Lively party's refusal to withdraw the subpoenas pending further meet and confer efforts, the then impending holiday weekend, and the fast approaching return date of the subpoenas, the Wayfarer parties had no reasonable alternative but to move to quash. We respectfully reiterate our request that the court quash the subpoenas as promptly as possible. All right, guys, we'll have to wait and see what the judge says about that. We're also going to have to wait and see what Blake Lively puts in her amended complaint, which is, I guess, technically they were going to have it due today, but since it's a holiday, it'd be due tomorrow. I'll keep an eye out on the docket and then we'll go over it together once it's available. Don't forget to hit the like button, it really helps my channel out. I got to get to work. See you later.